120 WPM English shorthand dictation. Be ready for it. Ready? Start. Para. Contract which cannot now be executed keeping in view the policy decision of the state government under the notification dated 2/2/2016 full stop. Having considered the submissions, what we find is that keeping in view the provisions of section 15 of the 1878 act read with the provisions of clause 21 of the general clauses act 1897, the power is there with the state government and it can as a matter of policy withdraw its authority to collect toll on any bridge or ferry full stop. Consequently, the power of the government is therefore available and the action cannot be said to be without authority in law. Para. The question is about the impact of such an order on the petitioner's contract. Full stop. The petitioner contends that this amounts to cancellation of the lease which has not been done in accordance with 1878 Act, that too even without affording opportunity of hearing or notice full stop. Here the petitioner will have to face the principles of res judicature in as much as after the state government has taken a policy decision whereby the performance of the contract would become impossible, and secondly, in this situation a writ petition for the enforcement of the balance of the period of contract would not be maintainable, more so when the withdrawal of toll is in large public interest. This is a surmounting interest against the individual contractual interest of the petitioner full stop. The petitioner does not therefore have a vested right to claim the continuance of the contract after withdrawal by the state government through a valid policy decision full stop. Para. On the arguments advanced by the learned counsel for the petitioner is that if a statutory provision is there which governs the field on the contract entered into, then any rights vested under the said statutory exercise of power cannot be taken away by way of a notification as has been done in the present case full stop. We are not able to accept this proposition for the simple reason that the state government has issued the notification in exercise of its powers under the act, and we have already referred to section 15 of the 1878 acts read with the provisions of clause 21 of the general clauses act 1897 full stop. Consequently, none of the arguments hold any water full stop. The petitioner therefore may, consequent to such withdrawal, be entitled to get adjustment or claim with regard to the lease rent that may be permissible under terms and conditions of the contract and provisions of the 1878 Act as well as the rules in this regard. Para. The defendant contested the claim of the plaintiff, and in paragraph 14 of the written statement it was specifically stated that the suit land was earlier in possession of Tanku and thereafter it came in possession of the defendant full stop. The trial court dismissed the suit by judgment and decree dated 6/10/2012 full stop. Against the judgment and decree of the trial court, civil appeal number 227 of 2012 was filed by the plaintiff petitioner, which remains pending till date full stop. During pendency of the appeal, an application was moved for amendment in the plaint which came to be dismissed for non-prosecution, and therefore again an application was moved for amendment which came to be rejected by the impugned order dated 21/11/2016 passed by the appellate court, before which the appeal was pending. Full stop. By the amendment application, paragraph 4a was sought to be added in the plaint to take a plea that Tanku did not have any issue and that he used to reside with the plaintiff, and that during his lifetime Tanku had transferred possession as well as title of the suit property to. Full stop.